have it, the question now is that Clause 2 stand part, the commencement. Chris Hipkins.
Thank you very much, Mr Chair. Mr Chair, I'm very happy to take a call on the commencement clause of this bill and restate, I'm very pleased to, I'm quite looking forward to it actually, because I think, as I've said to the House before, commencement clauses are often underrated parts of legislation, because in fact the significance and importance of them to the overall piece of legislation is very, very important, and I can see the members opposite are really excited to learn a little bit more about the significance of this. So, clause number 2. On the surface of it, clause number 2 looks quite straightforward and simple. It states, this Act comes into force on the day after which it receives the royal assent. Now, of course, first up, it's slightly misleading, because at the moment it's not actually an Act, it's a bill. So the bill, of course, could say this bill becomes an Act and comes into force the day after which it receives the royal assent. But I think by convention, as with so many things in this House, by convention, we use the word Act even though it's a bill. But so much of what we do in this House, and particularly when it comes to the process around the royal assent, so much of what we do here is based upon convention. Now, one of the things that makes this an interesting bill, this is a private bill, so it's not a bill from the government, and it's not a member's bill. Now, by convention, bills are given the royal assent by the Governor-General on behalf of the head of state, in this case the Queen, on the recommendation of the Prime Minister. Now, most legislation passed by the Parliament is government legislation. The government votes in favour of it. Under MMP, of course, we have minority government. It's quite conceivable that a private bill or that a member's bill would be passed by the Parliament without the support of the government. And yet, of course, it is the Prime Minister who has to present to the head of state or the Governor-General acting on behalf of the head of state any legislation that needs to receive the royal assent. And of course, the Prime Minister is obliged to do that by convention. By convention, it is the Prime Minister that would do that. And of course, by convention, the Governor-General, acting on behalf of the Queen as our head of state, is obliged to sign it. But, as Keith Locke mentioned before, they do have a reserve power. The royal assent can be refused. So there is no specificity about when this bill will actually become the law, because it will become the law the day after which it receives the royal assent. Of course, that assumes Parliament passes it. The Prime Minister presents it to the Governor-General. We don't know how long it would be between the Parliament passing it and the Prime Minister presenting it to the Governor-General. And then, of course, the Governor-General could withhold their assent, the royal assent, and therefore this bill wouldn't become law if they did that. There is no criteria in our constitutional framework for the Governor-General to withhold the royal assent. And of course there's nothing that Parliament could do about it if the Governor-General decided to do that. Now, of course, there are provisions in the constitutions of other countries who have similar clauses in their legislation which allow them ways around that should the royal assent be refused. For example, and I think this is quite fascinating, the Belgian Parliament passed a piece of legislation presented to their king for royal assent. It was a piece of legislation to do with abortion. The king said, I'm morally offended by this, I'm opposed to it, therefore I'm going to refuse the royal assent. Now, the Parliament, fascinating as this particular piece of constitutional history, the Parliament decided they would use a clause in their constitutional framework that allowed them to just deem that the king was unable to execute the duties of his office and was therefore effectively removed as king for one day. If that happens, the Prime Minister can then sign the legislation and it becomes law. So the Cabinet, all of the ministers signed a letter saying that they thought the king was unable to execute his duties on that day. Prime Minister signed the law. The next day, it became the law, even though the king had refused the royal assent. In New Zealand, we don't have a similar provision. Now, interestingly, the reason it was particularly interesting in Belgium was that clause was designed for if the king goes mad. It was designed for, it was never designed to be something that you would just use for one day and say, well, the king doesn't agree with us and we don't agree with him withholding the royal assent, so we're going to remove him for a day or for this signing of this piece of legislation, and then everything will just go back to normal. It was designed for, king going mad, basically. And of course that's happened before. We only need to look in the history books. Quite relevant on a bill to do with the Royal Society, one would say. it's quite conceivable that the monarch would go mad, refuse the royal assent. In this case here, they could have, Mr. Chair.
I'm bound to give them in.
Thank you, Mr. Chair. And the head of state, in this case the king or queen, could refuse to give the royal assent to this piece of legislation. Not a thing that this Parliament could therefore do about it, because we don't have a provision, as they do in Belgium, where they can sign a letter, where all the ministers can sign a letter, remove the king for just the duration of that particular piece of legislation, sign it off, and it all becomes law. Thankfully, very, very few instances where the head of state has, the king, queen, has refused to give the royal assent to legislation in New Zealand. In fact, I'm not actually aware of any, but somebody may want to correct me on that. I am aware that there was one instance in Australia where it did happen rather controversially, but not as far as I know in New Zealand. I don't think the royal assent has ever been refused. But of course, I think the point that all of this comes back to is that by the convention that we use in this House, and this is pretty much the same wording you'll find in most bills passed by this House, that it comes into force on the day after which it receives the royal assent. It doesn't actually give any assurance, any certainty to anyone as to when this particular bill or particular piece of legislation will actually become the law. And so possibly in the review of our constitutional arrangements, which is going on at the moment, that's something that we might want to think about. We might want to think a little more carefully about the reserve powers of the Governor-General acting on behalf of the Queen, their ability to effectively overturn legislation passed by this democratically elected Parliament, this House of Representatives, this people's representatives in this House. Should we have someone who is unelected, who basically holds their office by virtue of who their parents were and their gender, quite often, should that person, being so undemocratically appointed as they are, be able to veto legislation passed by a democratically elected Parliament? My view is that they shouldn't, and therefore we might want to think about that in our review of the constitutional arrangements which is currently taking place. So I think I'll leave it there, Mr. Chair. Thank you.
Colin King.
I move that the question be now put.
I think